Hi, I'm Shull with John Scott Real Estate. I wanted to make this video to let you know that real estate in Washington State is about to dramatically change beginning the new year. For years, real estate brokerage firms were only required to enter into written agreements with sellers, not buyers. Beginning January 1st, 2024, the agency law will require firms to enter into a written brokerage services agreement with any party the firm represents, both buyers and sellers. This change to ensure that buyers, in addition to sellers, clearly understands the terms of the firm's representation and compensation. The revisions modernize the 25-year-old law, provide additional transparency and consumer protection, and to acknowledge the importance of buyer representation. Several class action lawsuits are currently progressing nationwide. To delve straight into the matter, let's discuss the current status of these lawsuits and their implications for us in Washington State. These legal actions stem from a rule within multiple listing services, which dictates that compensation to a buyer broker must be facilitated through a sharing arrangement initiated by the listing firm. In essence, sellers offer compensation to a listing firm, and the listing firm later shares this compensation with the buyer broker firm. The essential allegations are that it is unfair for MLSs to have a rule that requires sellers to compensate the broker in the transaction whose sole purpose is to drive down the price and terms of the buyer, and that the members of the MLS require that the compensation offered by the seller be at a certain level, or the members of the MLS will not sell the seller's home. Now, many of you may disagree with both of those allegations, but those are the allegations asserted by some plaintiffs. And then the final allegation that's at the heart of these lawsuits is that buyers are without a voice in the negotiations regarding compensation that a buyer pays to the buyer broker by funding the purchase price of the property. Everyone knows that through this commission sharing arrangement, the compensation paid actually shows up in the seller's column on the settlement statement at closing. But that comes from the seller's proceeds, and the seller's proceeds are funded through buyer payment of the purchase price, so undeniably, seller and buyer both play a role in paying the compensation earned by buyer brokers and listing brokers in a transaction. Buyers argue that it is unfair that although they fund the compensation, they have no voice in determining the amount of compensation, and even if a buyer successfully negotiates a reduction in compensation to the buyer broker, the buyer will receive no benefit from that negotiation because based on the commission sharing arrangement, any reduction in the buyer broker compensation goes back to the listing firm because of the commission sharing arrangement. These are the allegations at the heart of all the litigation that's pending out there. In Washington State, our focus over the past few years has been on building a real estate industry that prioritizes transparency for both buyers and sellers. This transparency extends to understanding the agency relationship and the compensation involved in transactions. In our state, we operate within an MLS where sellers have the flexibility to offer zero compensation to a buyer broker, a practice permitted by Northwest MLS rules. Listing brokers make sellers aware of this option in our listing agreements. Sellers have the freedom to offer any amount of compensation to a buyer broker, clearly stated on the public-facing MLS printout and reiterated on the purchase and sale agreement above the buyer's signature. This ensures that buyers are fully informed about the compensation being offered to the buyer broker. One unique aspect in Washington State is the decoupling of compensation. Instead of adhering to commission sharing rules, most brokers invite sellers to make separate offers of compensation to the listing firm and, if desired, the buyer broker's firm. This practice is aimed at providing clarity and transparency in compensation negotiations. Starting January 1st, as part of the revised agency law, every buyer is required to enter into a buyer agency agreement or a brokerage services agreement with their broker at the beginning of the relationship. Before any substantive real estate services are delivered, buyers will be informed of the broker's compensation, agreeing to pay it directly or by having the broker negotiate with the seller. This separate negotiation allows buyers to benefit if the seller has offered greater compensation than what was negotiated between the buyer and the buyer broker. In essence, every allegation at the core of plaintiffs' claims, whether they are sellers or buyers, has been or will be accommodated by Washington practices and law by January 1st. This proactive approach positions Washington as a leader in the nation's real estate practices, and all real estate professionals in the state should take pride in their efforts to ensure transparency and clarity in the industry. As legal challenges unfold across the country, rest assured that Washington State is well prepared. Thank you for watching this video, and should you have any questions, please feel free to reach out to me directly. I would be happy to assist in any way. Thank you.